Hello and good afternoon. I think we've made mention of this before, but we're actually working lawyers. We actually have a day job,
We do.
and which we like very much. We enjoy doing this too, but we actually were flying to Arizona this morning for a client matter. Got back just a little after noon, so we didn't have a chance to listen in live to the Lively versus Baldoni court hearing. I listened to what some of the other content creators had to say, Zach and Dave Neal. I also read a few articles just to see kind of what was going on. And I think Dave mentioned that, overall the hearing wasn't that exciting, which of course it wasn't. We predicted that. Most hearings aren't that exciting. But there is an issue that was argued pretty well this morning, as I understand it, about the protective order. And I'm not surprised. And so let's kind of revisit because we went over the arguments on the protective order before, but let's kind of revisit that and talk about what really is at the heart of that argument between the parties.
So it seems like, Keith, as we were discussing before we came on, there's two primary issues that were argued here. One had to do with the attorney's eyes only requirement that Blake Lively's team really wants in this protective order. And then the other issue had to do with famous texts. So I'll leave that hanging.
Yeah.
Why don't you address the attorney's eyes only issue, and then we can turn to the famous texts.
So the argument that was coming from Team Lively is we want a protective order where we can unilaterally designate documents as attorney's eyes only.
So what does that mean?
So what that means is that they can get their little stamp. They do it on PDF. They don't stamp it anymore, but they can stamp the document saying this is attorney's eyes only. Only the attorneys can see it, not the parties. And there's a few other groups that can see it besides the attorneys if you're preparing an expert witness. But by and large, it limits who can see that document, and it does not include the parties.
Can I ask a question?
Sure.
So Lively's attorneys, they want this stamp that says attorney's eyes only. And you're saying without consulting with the judge, without consulting with anybody, if they so choose to, they can stamp any document they want, attorney's eyes only. And as a general rule, it'll be treated as attorney's eyes only unless Baldoni's team takes that document to the judge and asks the judge, hey, we don't want attorney's eyes only on there. Is that the issue?
That's the issue. That's what Lively wants. What Team Baldoni wants is they're saying, look, we'll agree to a protective order. We can stamp documents confidential, which means that the parties can see it, the attorneys can see it, the outside world cannot see it. But when it comes to attorney's eyes only, let's just do it on a case-by-case basis. If you think that you have something that should be attorney's eyes only, let's discuss it. And if we agree, then we'll designate that document or that set of documents as attorney's eyes only.
Okay, I've got more questions. I'm sorry. I'm a little slow today. So Baldoni's team says, well, let's get the stamp and mark them confidential, or anybody can mark them confidential if they so choose to.
Either side can.
Yeah, either side can. Anybody can. If you have a document you think is confidential, you can pop a stamp on there confidential. But why is there such a distinction between the attorney's eyes only stamp and the confidential stamp?
Well, because the parties can't see it. And
explain that. What does that mean?
What does that mean? You can see it, but you can't show it to, unless say you represented Justin Baldoni.
Right.
So I have some text, and I'm afraid that this is a damaging text for me. I'm representing Lively, let's say. And so I put attorney's eyes only on there. I'm going to unilaterally stamp it. I send it over to you. You look at the text and you say, well, this is interesting. I need to talk to my client about this.
Right.
No, you can't. You can't show it to him. You can't tell him what the contents of it is. Your lips are sealed.
So what was the court's view of this? I mean, from what you read, when the court's looking at the attorney's eyes only argument that's going on here, obviously Lively's team is arguing they want the unilateral right to do this, and Baldoni's team saying, hey, the court's model protective order is good enough with the confidential stamp only. So what did the court have to say about this?
It appears as though the judge was leaning a little bit more on the Baldoni side based on what I was seeing and reading, where they were asking the Lively side, well, give me some examples. What information are you so worried about where you need to be able to do this? And again, the issue comes back to marking a document unilaterally. Do you have the right to do that on your own, or should we have a system where the parties are going to come together and agree?
Okay. And as I understand it, the court took this under submission. What does it mean when a court says, I'm going to take this matter on this issue under submission?
It means they're going to give a ruling at a later date. And it usually means that the judge wants to sit down probably with the research attorneys and just look over the issue one more time, look at the law one more time, and think about what the best decision that could be made here. So it's not uncommon for a judge to hear argument in court. Happens to us all the time. And then the judge will say, I'll take it under submission, and a ruling will come within the next few days or a week or two, depending on how complicated the issue is.
So when we watch legal things on TV, legal series on TV, judges make decisions, boom, 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 really quickly, and cases are tried in an hour, and the jury, makes decisions quickly. That's not what's going on here. The court wants to take a little bit of time, review the arguments of the parties, review his own homework, talk with his lawyers, and then ultimately he will have a written decision that will come out.
Yeah, it's funny because I had a client years ago where we were doing a trial, and it was a bench trial, and we got to the very last day. We did closing arguments, and I could tell that like the client started to get kind of up in his seat and kind of like what's going on? Like he's getting very excited. And the judge says, okay, I'll take the matter under submission. And then she gets up and walks out, and he looked so disappointed. And I'm like, did you think she was going to rule right there? He's like, yeah, I thought she was going to rule right here in the courtroom. I'm like, oh, you've been watching too much TV. That's not how that works.
Okay, so then there's another issue, and this one's more interesting to me just because it's kind of gossipy, I guess. And there's this argument over famous text messages. What was that about?
Yeah, and the Lively side is saying that there's a significant chance of irreparable harm if we allow these text messages that Lively supposedly had with her celebrity friends. And on the one hand, they're saying, well, it could disclose sensitive information like home addresses, and that could be a security risk. It also could divulge conversations that aren't directly related to the case. It's kind of funny because it's similar to the arguments that they fought when they tried to get all of Baldoni's texts, and now they're kind of rehashing the same arguments. But in other words, I think what people are speculating, or what I've heard, is that they're thinking of, oh, there's some texts that Lively had with her celebrity friends, and now she's trying to hide those texts by saying that there's security risks. I mean, that's kind of the impression, I guess, of that argument. That may or may not be true. I mean, when you look at, different text messages, I don't know if she's hiding anything or not, but that was kind of the crux of the argument on Team Lively side. And of course, Friedman argues exactly what you would think, which is a very commonsensical argument, which is, hey, look, celebrities are subject to the same standards as everybody else. So just because they're celebrities doesn't mean they get to hide their texts.
Yeah, if I have to turn my texts over in a case and they're very private to me, why shouldn't these A-listers who are text messaging back and forth with Ryan Reynolds or with Blake Lively? And I think the interesting thing here too is, what if they're an A-lister and they're talking about this case,
right? And
they're talking about things that are relevant to this case. Essentially, under Blake Lively's position, they could preclude turning over those texts, which would be very interesting for the other side to see, to evaluate the case. So that could be a problem going forward.
Yeah, and it's kind of an ironic argument for the Lively side, I suppose, because they had no problem disclosing tons of texts. I didn't say that right.
Texas. That's Texas. Yeah, that's okay. That's all right.
Multiple texts between Nathan and Abel.
Right.
And so the PR people for Baldoni. And so their complaint is riddled with texts.
If you remember that our jury pool are people that keep us honest here with their comments and their questions. They actually have been asking, why doesn't Baldoni take the same tact and ask for all of her text messages? And so
it's coming.
What you're seeing here is what's good for the goose is good for the gander. So,
and that's coming. I mean, that Friedman's going to do that, and you also know that Team Lively knows that he's going to do that, and they're trying to head him off at the pass, so to speak.
Right.
And they want the ability to protect things with this attorney's eyes only designation. And Friedman also said, circling back to the attorney's eyes only thing, we shouldn't have to run to court and argue every time, because what's going to happen is they're going to over designate. That's what's going to happen. And then Friedman's going to have to come in and argue, every single one. He's like, look, don't do that. Let's just come together on a case by case basis and we'll figure it out.
So can I be very, very unfair to you right now?
Sure.
What do you think the court's going to do on both of the issues of the attorney's eyes only designation stamp that Team Lively wants to use liberally, presumably, and the famous text communications that Lively wants to restrict the amount of text that she has to turn over to the other side? And again, this is kind of interesting. This just hit me. who is an A-lister, who is a person,
Yeah,
you
right.
know,
Right. Yeah, you can start insulting some people.
So
You know,
anyway,
it's like, hey, you released my stuff. I thought it was an A-lister.
yeah.
No, you're only like a B, C, you know.
Right.
Yeah.
Or do you designate a Z-lister because the text is just so
Right.
bad it's going to kill you? And
Right.
you say, well, that guy was kind of in the public
Yeah.
realm, you know. So
Yeah. If you were in a sitcom or a major movie in the last 15 years, or so, I mean, what's the standard?
I held the
don't know.
mic. I held the mic at the
The boom
sitcom.
mic.
Yeah. So
Yeah. But so if I was the judge, what I would be thinking is, what ruling can I make here that will keep these people out of my courtroom as much as possible
Okay.
on discovery disputes?
All
Because
right.
judges hate discovery disputes, and it's often been likened to two kids arguing in a sandbox box over the toys. And so it seems to me that it's probably better not to give the unilateral ability to designate attorneys eyes only and maybe do it on a case by case basis. That might be a better way to go. That'll keep people from coming in and arguing in the future over every single discovery dispute. And then maybe you give the Lively team a little, throw them a little something and say, but you're certainly within your rights to redact any addresses, personal information, and maybe only that type of information is designated under an attorney's eyes only type of stamp. So it's probably going to be something along those lines would be my guess.
And the famous text.
Yeah, I think the texts have to be produced, but I think that the judge could say that any personal information like addresses, phone numbers,
Okay. So
email addresses. Yeah.
you just addressed that, and I asked that twice. That was beautiful.
Yeah, we can go over to third time.
I did. Yes. I might need it today. So I guess, one of the arguments I thought I saw when I was briefly looking over some of the stuff you were looking at earlier was Lively's team was arguing that the desire of Baldoni to turn over salacious text messages that are from A-list celebrities is just too strong, and that he literally would defy the court's order and turn this stuff over by leaking it out. What did you think of that argument?
I don't find it very persuasive. I mean, somebody who's in the case at Baldoni's level certainly would know the stakes of doing that. I think the problem on both sides, and we addressed this before when we were looking at the actual arguments and the protective orders, is that even with the attorney's eyes only designation, the documents can still go to things like copy services or expert witnesses. And I think that's where the problems are going to be, because there could be, and I don't want to, disparage any copy services, but there could be people working at a copy service where the information is available and it's very valuable, and they could sell it to TMZ or whatever and get some money for it. But I don't see
two lawyers.
Oh yeah. Yeah. Well, we're not exactly paying big money for information, but
Maybe not. I don't know. Depends on what the information is.
right. But I don't find that very credible. So I mean, I don't think the parties are going to go out of their way to disclose things because they know the stakes of that. They could get very badly hurt in the litigation if they screw around with stuff like that.
Yeah, the court can issue all types of sanctions, including striking their answer, precluding testimony. I mean, there's all kinds of things the judge could do to punish bad behavior. I don't think federal judges, no judge, even state judges, aren't to be trifled with, aren't to be messed with, but certainly not federal judges. And I thought the argument was a little bit kind of like, well, judge, you're not that strong. You know that this desire of Baldoni and his team to turn this stuff over, they're just going to go against your order. And it's kind of like you're arguing to the judge that the judge doesn't have power to tell people don't do this. And I do think that if Baldoni's team did leak this information and it could be traced back somehow, some way to his team, the punishment would be severe. And so, again, it's kind of interesting because I'm hearing arguments from Blake Lively's side that I kind of get the feeling that they want special treatment in a case because there's celebrities involved. And what about everybody else?
Yeah.
What about all of us that have to
show your dirty laundry,
go to federal district court or state court or show up for a deposition or produce documents per a subpoena? We all have to do this, right? And just because you're a celebrity, God bless you, you've done well in life. There shouldn't be some protection for you that's different than for the ordinary average person like us or anybody listening. Everybody should be subject to the same set of rules.
Yeah, absolutely. And if you look at like in California, if you look at the Code of Civil Procedure that has our Discovery Act in it, There's no special rules for celebrities in there. I've been doing this for a long time. I've never seen a rule for celebrities.
Well, and we had talked to several people about this, and that has to do with the idea that A-listers saying, "Well, my schedule doesn't allow for me to have a deposition taken,"
Right.
as if everybody, some people are working 2 jobs, some people are working 3 jobs, some
Right.
people are going to school and working. When we get our jury service notice, we all groan because we realize it's going to
Don't have the time.
It's going to take a day away from what we're doing. So again, I think maybe the arguments here, they need to be careful because they've already, in my mind, they've lost so far in the court of public opinion. They being Blake Lively and her team, and I think it's because there's a little bit of people saying, "Gosh, these guys were bullies. These guys bullied Baldoni. They took advantage of their position. They're powerful people in the entertainment industry." And now they're coming into court with arguments that appear to be looking for some preferential treatment, which ultimately that preferential treatment is going to be used by the lawyers to the best advantage they can. And that means if there is a text message from an A-lister out there where Ryan Reynolds or Blake Lively or somebody on that side, and I'm not saying this did happen, I'm just saying somebody says something very poorly about Justin Baldoni or an admission that is very hurtful to the case, and they say it to an A-lister, I mean, lawyers, if they have the right to mark that attorney's eyes only, they're going to mark that attorney's eyes only. And that's not right. They shouldn't be able to do that.
Well, remember that a protective order is for sensitive information. It's not for bad evidence. And so when you have a protective order, you're trying to protect things like trade secrets that could be damaging, medical records that could be embarrassing. You're not trying to protect bad evidence. I mean, that's not the purpose of a protective order. And so for the Lively team to argue, we don't want to produce a text because it could be disclosed, like in a court filing. Well, if it's just bad evidence for you because there was some text between, Lively and some other celebrity talking about Baldoni, well, you don't get a right to just protect that because you don't like it. That's not what protective orders are about.
Well, it's going to be interesting to see. This judge has gone quick so far, or has made decisions quickly. And so once we do see an order come out, we'll certainly jump on here and address it and go through that.
Yeah, it'll be interesting to see how the judge rules. We have seen some questions in the comments too about why is this case in federal court? And we thought, it probably wouldn't be a bad idea just to give a quick summary of kind of how the federal jurisdiction works and, hopefully not bore everybody to death, but in a nutshell.
Well, if you're here for your daily dose of Lively versus Baldoni, we are going to transition. We may allude back to it with an example or two, but if you need to move on, if your day's busy, we certainly understand. But we did want to talk briefly about how the court system works. There's a federal court system and there's state court system. So every state has its own set of courts, and then of course the entire federal system has its own set of courts. And generally speaking, there is a trial court at the very bottom. And when I say the very bottom of that level, it doesn't mean that this is not an important court. This is where trials happen. So when you saw the O.J. Simpson trial happen, that was an L.A. Superior Court. That's a California state court. It's the bottom court in the state, but it's where trials happen. It's where, people are asked questions. They're cross-examined. There's direct examination. There's opening statements in front of juries. There's closing statements. Juries are there. They deliberate there. They make decisions, and then judges are there, and the parties are there. That's where all the action is in the bottom court, in whether you're talking about the state systems or you're talking about the federal system. In the federal system, we call it the Federal District Court. And so we're in the Southern District of New York right now for the Baldoni case. That is the district court. That is the bottom court in the federal system in New York. So the question is why was this case filed in state court in California? And then why is it in a federal district court up in New York? And that has to come with 2 different types of analyses. One is the only way you can get into federal court. There's only 2 ways you can get into federal court out of any other court in any of the other states. One is you have a federal question that needs to be answered. And that's something that is constitutional. Okay. If you want the right to have an abortion and Texas is denying you that right, you have a right to take that to the federal district court and argue in a trial whether you have a right to have an abortion under the Constitution of the United States or any other federal statute that you can point to, federal law that would say, I should have the right to do this.
So issues of federal law or issues of the U.S. Constitution go to federal court.
Yes. And then would you explain diversity jurisdiction? The second way you can get into federal court is diversity jurisdiction. And that's what's going on here to some extent. So talk to us about diversity jurisdiction.
So that's where you have a citizen of one state suing a citizen of another state. So if you have a plaintiff who's a citizen of California and a defendant who's a citizen of New York, you have the right to sue that defendant in New York State court because they have jurisdiction over that defendant. Or if the amount of controversy is over $75,000, you can take your case to New York federal court, with the idea being that since the plaintiff and the defendant are from two different states, it may not be fair to have the matter decided in state court, where the state court might rule in favor of their own state citizen. And instead, you can take it to federal court. And we call that diversity of jurisdiction.
Okay. And then to add one more layer to it, many times big defendants, Apple, IBM, hospitals, medical device manufacturers, big companies, if I sue them in California state court, remember the bottom court, the trial court, if I sue them there and they don't have minimum contacts or they don't have substantial contacts with California, and let's say they're in Delaware or something like that, they can remove the case to federal court because there's diversity in that case, right?
Yeah.
And how do we defeat diversity when we're suing like a medical device manufacturer that's back in Delaware? They're not in California. They don't have the principal place of business here in California. How do we defeat their ability to take us up to federal court?
If you have one person on the other side that's also from the same state as the plaintiff. And so that's where you would destroy diversity.
So Keith and I, many years ago, and we won't bore you with details, we sued many medical device manufacturers who implanted dangerous or allowed dangerous products, in our opinion, to be implanted in people. And so what we did is we would sue them, but we'd also sue the doctor who did the surgery to implant the device. And invariably, the doctor and our client are from the state of California or from the same state. And once we have two people on the same state, and then you have this defendant that's from somewhere else outside of California, that defeats diversity jurisdiction, right?
Yeah, that's right.
So that's clear as mud, I'm sure. This takes law students a long time to get this understanding. But what I really want to point out is there's state courts and there's federal courts. Here we're in federal courts with Blake Lively versus Justin Baldoni. Yeah. It did start in state court in California, but now it is
it started in the state CRD complaint.
I'm sorry, state CRD. And then it was headed towards California state court, and then it moved up to New York. Sorry about that. So then, what about, what happens if you lose at the trial court? This is the bottom court in the state or in the federal courts. Do you have an absolute right to appeal the decision of the jury or the judge at the trial court level?
Yes, you can appeal most things. There's a few things that are unappealable, but by and large, you can appeal. But you don't get a whole new trial. There's very limited rules. But yeah, you can take it up to the Court of Appeals, which is the federal system has.
And when we go to the Court of Appeal, do we get the same witnesses and put them on the stand and we go through all the evidence again? Is that how that works?
No, there's very limited standards on appeal, and it's probably too much to go into here, but you don't get a whole new trial. You have to argue certain things, and only certain things can be upended on appeal, I suppose. And then if the appellate court wants to, they can send it back down to the district court and say, you need to have a new trial.
New trial, or in most cases when you appeal, and it's unfortunate for people that lose at the trial court level, probably 90% plus of the time, the appellate court, what do? They affirm the trial court's decision and the case is over, right?
Yeah.
So if we know we have an absolute right to go to the Court of Appeal above the trial court, why do we have Supreme Courts that are above the appellate courts if we only have a one-time bite at the apple of appealing a trial court's decision?
Because the Supreme Court of the U.S., and this is true of Supreme Courts at the state level too, with the U.S., you go up on a writ of certiorari, which really means the Supreme Court has the option of taking the issue up if they want to. You don't have a right to go to the Supreme Court, but the Supreme Court could look at the issue and say, oh, that's interesting. We need to decide that. And a lot of times, like in the California Supreme Court, they'll decide issues where there's a split of decisions among the appellate courts, or if it's a major issue that they want to have a voice in. And so you'll see the U.S. Supreme Court do the same thing. They take very few cases, percentage-wise, they take very few cases up to the Supreme Court.
Maybe 100 cases or so a year by the United States Supreme Court. And then every state court's a little different. I think California took 150 cases or so. So it's really hard to get in front of a U.S. Supreme Court, or a state Supreme Court. So I just wanted to add briefly here, just a very boring geographic boundaries. This is just showing the United States appellate courts and the circuits that are out there. There's 12 circuits. And under those 12 circuits, the 12 circuits are the appellate court, are 94 district courts. 94 trial courts, in other words. So there's 94 federal district courts. One of those 94 courts is the Southern District of New York, where the Blake Lively and Justin Baldoni case is. Okay, and that's at the federal district court there. So that's one of the 94 courts in the nation that's a federal district court. That's where the trials happen. Those federal district courts, those 94 federal district courts are essentially overseen by these 13 circuit courts of appeal. So many people talk about, if you look at the yellow on the map there, that's the Ninth Circuit Court of Appeal. Look how many states the Ninth Circuit has. It has Idaho, California, Nevada, Arizona, Oregon, Washington. I think is that Wyoming at the top there? I can't see. But anyway, that's the Ninth Circuit Court of Montana. Yeah. Sorry, Montana. I've been there. It's a beautiful state. So you've got this Ninth Circuit. And if you remember, if people heard in the news, the Ninth Circuit's so liberal and the Ninth Circuit's always being overturned by the Supreme Court. That's the Ninth Circuit. There it is. And then if you look all the way up here in New York over here, you're going to see the Second District. And that's where the Blake Lively and Justin Baldoni case is taking place. And I think it's Vermont, Connecticut, and New York is the Second District. If you come down here to the bottom where Florida is, you got Florida, and it's, what is it? Is it Georgia and Alabama that are part of the 11th District? So that's the 11th Circuit Court of Appeals that oversees the district courts that are in that area. So all of those 13 circuit courts out there overseeing the 94 district courts. So what happens when a issue is filed in the district court, like this USAID issue where President Trump decided that he and his administration decided that they weren't going to give any more foreign money under the USAID contracts that had been signed previously under another administration. That went to the district court, the federal district court, where there was a ruling. There wasn't a trial, but there was a ruling. And then it went up to the U.S. Supreme Court. The U.S. Supreme Court took it. And in that case, I believe, I forget the name of the case here. It is Department of State versus AIDS Coalition et al.
Yeah, this is really, in my mind, this is the USAID case. So this is the case where the Supreme Court decided not to intervene on the USAID case.
And we know that this was a 5-4 decision. And Keith, just before we get started, I do want to pull up the justices of the Supreme Court, because I think a lot of people don't know this is the third branch of government. It's some of the most powerful people on the planet, and a lot of people don't know who they are. And I think I can share this and show just a few people. Let me pull this over here. Sorry, I'm doing 3 things at once here. Okay, so this is John G. Roberts, and he is the Chief Justice of the Supreme Court. He was put into office by George W. Bush. George W. Bush nominated him. He made it past the Senate confirmation, and he is now the Chief Justice of the U.S. Supreme Court. There are 9 judges on the U.S. Supreme Court, but he's the Chief Justice. So he sits in the middle, and he has some other administrative duties that the other justices don't have.
Right.
But he doesn't have any more power, I would say. I mean, he has power of case selection and so forth, and who gets to write the opinions and so forth. But when it comes to voting, he's got the same vote. Okay, and he's mostly conservative in his decision making, but he's also swung to the liberal side time to time and surprised people that they would think he would vote conservative on everything. All right, next we have Clarence Thomas, and some people remember him from the Anita Hill fame of the 1980s, where there was an SH complaint made against Thomas, Justice Thomas. He was appointed by George H.W. Bush. That was the first President Bush. That would have been the 90s, I think, when all that was happening. I remember that. Yeah, and he is probably the most conservative member of the Supreme Court.
Yeah.
So he's there, and I guess his wife is involved with a lot of things.
And the one who takes the most vacations.
And takes vacations. And there was also some conflicts of interest things that recently came out in the news about, some he got to go on some yachts and got to go on some airplanes and things like that. Yeah. So
not a good look.
Yeah. Next is Samuel Alito, and he was appointed by George W. Bush, and he's also on the conservative wing. Maybe close to as conservative as Justice Thomas is, but not quite as conservative. Next would be Sonia Sotomayor, and she was appointed by President Obama. So that should lead you to understand she's on the liberal wing of the court, right? What's interesting about this court is there's 3 liberals that are on the court now, Sonia Sotomayor being one of them. And there's I guess you would say 5 conservatives.
Yeah.
And then John Roberts being mostly conservative, but swinging to the liberal side from time to time. Yeah. And then next we have Elena Kagan. And Elena Kagan, she was appointed by President Obama. She's a liberal. So she's one of the 3 liberals that are on the court right now. And then you get you get 2 of the trifecta that President Trump. I mean, I don't know if people understand how amazing it was that President Trump had the 3 justices appointed to the Supreme Court. And the reason this matters,
in his first term, that's just one term.
In one term, why does it matter that you as a president get 3 Supreme Court justices?
Well, you get to recast the court. I mean, that's a huge
but
voting block.
Why is that? Because they have a what?
A huge voting block majority.
Well, they have a lifetime appointment, right?
Well, that too, yeah.
Yeah. So the lifetime appointment of these people, they're not up for a re-election. There's not a term that they're set up there. They're there forever. And if you put a really conservative person on the Supreme Court, if you put a really liberal person on the Supreme Court as a president, that means your legacy can be continued.
And in recent history, these people die in office, right? Rehnquist, Scalia,
Ruth Bader Ginsburg.
Yeah, I mean, they go down in the saddle.
So anyway, Neil Gorsuch, one of the Trump appointees. And then you got Brett Kavanaugh. He's also a Trump appointee. And again, very conservative.
Yeah.
And then finally, Amy Coney Barrett. Brilliant. If you got to watch her confirmation hearings, she is, I mean, just ridiculously off the chart smart. Maybe the smartest member on the Supreme. They're all brilliant people, by the way, but she is just so bright. Saw her at the congressional speech the other night where she shook hands with President Trump. And then the final member of the Supreme Court, and she's in the liberal wing, is Ketanji Brown Jackson, and she was appointed by President Biden. He got 1 person. And, so now Trump is looking at these 9 thinking, is anybody going to retire here? Is anybody going to pass away? Then he can actually get a 4th or perhaps 5th Supreme Court justice who is a lifetime appointment, and they will be there forever, and they can see the legacy going forward, which leads me into my question for you, Keith, and that is this decision that just came down from the Supreme Court on the USAID was a 5-4 decision.
It was.
And the 5-4 decision, Amy Coney Barrett ruled against the Trump administration.
Well, arguably, I'm going to take issue with that. But
okay,
yes,
walk me through that.
Because in my mind, I think, it's funny because I read all these news reports about how the U.S. Supreme Court ruled against Trump. And so it's like, okay, well, let's take a look at the ruling. And it's actually not even that long of a ruling for the U.S. Supreme Court. It's only 9 pages. The majority ruling is really just one long paragraph. And really what the court did, the majority did, is they said, well, we're not going to upend what the district court did in terms of the temporary restraining order. We're just going to send it back down to the district court and ask them to clarify what obligations the government is supposed to pay and what it's not supposed to pay. And that's the blue highlight right there. So, it's funny because what people don't understand is that the court, especially appellate courts, and especially the U.S. Supreme Court, they're very procedurally driven. Like they don't want to decide things unless it's before them properly. And you'll see this all the time in appellate court decisions and Supreme Court decisions. But you can see here that the district court should clarify what obligations the government must fulfill to ensure compliance with the temporary restraining order with due regard for the feasibility of any compliance timelines. Well, to me, that doesn't look like the 5 in the majority on the Supreme Court said the district court is right and the Trump administration is wrong. It might still come to that. They might still make that ruling. It looks to me more like the Supreme Court said, we need some more clarification from the district court. So go down district court and clarify a few things for us. And then it can come back up through the appellate court and the U.S. Supreme Court. The issue, I think, and what really kind of made a splash is there was 4 justices in the minority who did a dissenting opinion. And if you go down to the next page, and we just look at that kind of top paragraph that starts with, does a single district court judge? And this was, again, this was Alito, Thomas, Gorsuch, and Kavanaugh. And the minority...
Can you just explain just briefly, and I apologize for interrupting, can you explain what is a dissenting opinion?
Yeah, so anytime the U.S. Supreme Court makes a decision, there'll be the justices in the majority. That will be the decision of the court, and the majority, somebody within that majority will write the opinion, and then the people who
so the 5
who voted for it.
are there in the majority.
Yeah. And then the 4 who voted against it or voted in a different way, they didn't side with the 5 in the majority, they're the minority. And if they want to, they can write what we call a dissenting opinion. So they can give their rationale for why they disagree. They don't have to. Not every decision has a dissenting opinion, but this one does.
You agree with me that 2 of the justices that President Trump appointed during his first term as president are in this minority dissenting opinion.
Yeah.
And Amy Coney Barrett, who he also appointed, is not.
Is not, yeah.
Okay.
But I still don't think the majority necessarily ruled in favor or against Trump. I think the majority, in my mind, ruled on, for lack of a better word, a technicality. We need more information. Now, here, the 4 people in the minority says, well, we just want to get to the meat of the issue. Why can't we just decide the underlying issue right now? And so they're saying, does a single district court judge who likely lacks jurisdiction have the unchecked power to compel the government of the United States to pay out $2 billion in taxpayer dollars? And they say the answer to that question should be an emphatic no. And so they want to actually get to the underlying issue right here and right now, which is kind of interesting. Again, Supreme Court is just always so procedurally driven. So I think that's the problem. And really what the minority is saying is that, look, a temporary restraining order is supposed to be temporary. That's the whole point of it. And it's supposed to stop somebody from taking an action that would be irreparable harm. That's the premise. And then, usually a temporary restraining order is good for 5 days, 10 days, very short amount of time. And then the court has a follow-up hearing to figure out if there should be a permanent injunction. And really what the district court did here is they issued a temporary restraining order that essentially stopped the pause on payments, which means this is where it gets confusing because it's like opposite. Because the district court wasn't stopping something, they were stopping the government from stopping something.
In other words, they were enforcing these contracts and enforcing the aid that had previously been pledged to other foreign entities, that this money had to be paid.
Yeah, so the district court was essentially saying you have to pay it. And you're thinking, wait a minute, paying something is irreparable harm, isn't it? Or it could be if we decide that it shouldn't be paid. And so I think that's where the minority had a problem with this and said, wait a minute, it seems like this is an opposite land where you're forcing somebody to pay something, the government to pay something, when shouldn't we do just the opposite? Say, let's put a freeze on everything. Let's hold everything. We'll figure out what the issues are. And then if it needs to be paid, go ahead and pay it. And so I think that's kind of where the issue came down for the minority. They also, they had an argument in here about how, so right here at the top, it says the government quickly filed an appeal in the United States Court of Appeal for the District Court, which you talked about. And what they're arguing is that it's going to take too long. So the people who aren't getting the $2 billion are going to be harmed. And the courts, this minority here is saying, but it's not going to take that long. I mean, just, tee it up for the appellate court. The appellate court will rule. It won't take that long. And then you'll have a decision.
To be clear, Keith, while you're collecting your thoughts there, isn't it true that some of these contracts that were canceled include money going to fight an outbreak of Ebola and also certain countries that have been really hit hard with HIV? And so these people are saying, look, this is a desperate situation. If you cut this money off, then we don't have the money to spend on stopping Ebola, stopping the spread of HIV, potentially AIDS. And so we need this money. And so I think you've got a district court here that's saying, hey, you got to send this out. Supreme Court saying, well, maybe you have to send this out. Maybe you don't, but we're going to send it back for further clarification.
That's what the majority is saying. So, I mean, I don't think we need to show a whole much more of this opinion. We'll go ahead and put a link to it if you actually want to get down and read it.
But it seems to me that Amy Coney Barrett, who was appointed or nominated and then appointed by the Senate to the Supreme Court by President Trump, if she would have gone from the majority of 5-4 and joined these 4 in the minority, then they would have become the majority.
Yeah.
And what would have happened then?
The Supreme Court would have issued probably an order to the lower court to say you need to enjoin the payment of this $2 billion until we figure this out. And so that's, again, the dissenting people wanted to get to the crux of the issue. Let's just do this or don't do this. Whereas the majority was saying, well, the deadline that the district court set had already passed, and we need more clarification. So let's just have the district court clarify some things for us. The thing that kind of gets me about these is that you read the news and in these different articles on it, and it sounds like the Supreme Court came out against the Trump administration. And whether you like the Trump administration or you don't, it's just not, in my mind, an accurate portrayal of what this opinion is. In essence, this was kind of a technical opinion that had a technical answer, and it's not the end of the road for this case. There's more to come. So,
well, should we have a single federal district judge making a decision that $2 billion is going to leave the country and go to these foreign jurisdictions?
I don't think so. And that's one of the things that the dissent pointed out, is that, look, there's something called sovereign immunity here, where the government has a right as a sovereign to make big decisions like this. And it's not within the court's purview to be able to stop that. We have 3 independent branches of government. They each have their own unique powers. It's a wonderful system. It works. But just because you're a district court judge doesn't mean that you can necessarily step in here and stop the payment of money like that. But again, I don't think this court opinion is the end of the road. And I think there's more to come.
And sounds like it's back with the district court, federal district court. There will be another decision, which will inevitably, it sounds like, get teed up back to the U.S. Supreme Court, and then hopefully a resolution from the 9 justices that are up there.
Yeah. So I don't think it's the end of the road for this.
Okay.
Yeah.
All right. Well, we covered the Baldoni matter first. Now we've kind of given a flavor of how the federal courts work from a district court level, an appellate court level, and a Supreme Court level. And then we used a recent case that just came down this week on the USAID, where you have a federal district court making a decision that money still has to continue to be flowing out to these foreign jurisdictions under previous contracts, under a previous administration. And you got the U.S. Supreme Court not quite finding in favor of the Trump administration, but as maybe you're saying, sending it back to the federal district court for clarification, and then the issue can be teed up again.
Yeah, it'll be coming back up through the appellate courts again, I'm sure.
Okay. All right. Well, listen, we appreciate everybody's comments today. We'll read all of your comments, and if anything pops out to us, we can cover it in a future video that we'll be doing. So
yeah, we want to do a question and answer one soon. We've taken questions from the comments that we want to go through, and so maybe we need to do that in the next couple of days. Things have been coming at us so fast with the Lively versus Baldoni case that it's hard to find some time to work that in, but we'll do that.
Yeah,
hopefully.
Yeah. So all right, we'll see you guys later.